All right. So the new, and counsel, you're on this side.
Oh, sorry.
On the wrong side.
Good morning. Oh, no, you're in the center. It's just your client is on this side. All right. So the court is in receipt of the newly indicted case. Counsel, are you on that case as well?
Yes, Your Honor.
All right. So state, where are you on discovery with regards to your case?
I believe the defense requested things this morning. We provided her with 911 call. We're requesting another police report that might be missing. So we're in the process of trying to get all that to defense.
All right. Is there any child protective services involved in this case?
Correct.
All right.
That's another, Your Honor, if I may, we do not have CPS records. That's one thing that I'm requesting this morning. What the state indicated was the 911.
Everyone, please whisper.
The 911 call that I have in evidence is an opening, so they're putting it on a CD for me to see if that helps. I've also asked for an additional audio files for them to check with their detective. There are emails in discovery indicating that the detective spoke to the complaining witness's parents, and I'm asking them to check with their agency to see if there's any audio files that recorded that conversation, because
All right.
sometimes.
So you need to have a seat.
Additionally, Judge, I'm requesting SAPD 2404-6370, which is the original runaway case for this complaining witness.
All right. So let's slow it down a little bit.
Sorry, Judge.
Everyone, for the love of all that's holy, please whisper. Whisper as though you are spies. And if somebody can hear your conversation, that will mean the end of your life. All right.
May I continue, Judge?
Bashan, everyone here, if they were a spy, it would be over for them. Everybody would hear their conversation. All right. So you need CPS records.
Yes, Your Honor.
There are some audio files that may exist based upon your review of emails.
Yes, Your Honor.
All right. Do you have all of the emails?
Yes, Your Honor. They're in discovery, and I can forward them to the state if that would.
All right. So what else do you need?
Your Honor, there's a runaway case for the complainant that's connected to this case as well. I've given them that SAPD report number, Your Honor, and I'm requesting the discovery in that case.
All right.
Additionally, Judge, when the detectives speak to the complaining witness's parents, they indicate another person who may have been the cause of this. His name is Joseph Cortez. So I have requested the at-large case, which is JN 2171232. The state indicated that they would upload the police report, Your Honor, but I'm requesting all of that discovery because that is going to be important when I'm cross-examining all the witnesses, Judge.
All right. So,
Your Honor, for the record, that is sealed evidence.
oh, we're not on the record, but okay.
Well, that's sealed evidence, and it's not, can't be provided for discovery until the state decides if it's going to be indicted or not. It's an unindicted case.
All right. And this is
Unindicted at large.
on Cortez?
I'm the one she's referring to at the end. Yes, Your Honor.
Cortez?
Yes, Your Honor.
All right. So just file your motion for that. If they don't turn it over, we'll have a hearing.
Yes, Your Honor.
And state what I can tell you. If the defense cannot wait for you all to decide if you're going to indict a case or not, unseal it or not, because this may be a witness that may be exculpatory. Maybe it's not. Who knows?
Understood.
But if it's not turned over, file a motion and I'll have a hearing on it.
I will, Your Honor. Thank you.
All right. Is there anything else?
No, Your Honor. After our last hearing, they uploaded body cams, Your Honor, and from the SB, from the report that the detective put together, I believe that's all the body cams available, Judge. And from my view of the evidence, I don't believe we're missing any body cams. It's just what I indicated on the record today.
All right. So we're going to recall this for discovery. And what I'll do, counsel, if there's no objection, I'll recall it in 45 days because it may take time for the CPS records because, sir, this is how Child Protective Services work. If the state already has the CPS records in their physical possession, then it'll be quite simple to get the CPS records. But if it's not in their hands or in the prosecutor's hand who handled the CPS cases, it's going to take a while. Because if you can imagine, in Bexar County, Texas, there are a lot of Child Protective Services cases, and they have to pull all of the records. And sometimes the records will be duplicates. So your attorney may end up with 2,000 pages of records, but only 1,000 of them are original. All right. So I'm trying to make sure that your attorney has all of the evidence so she can represent you. All right. And not be hit with surprises. Okay. So what I can tell you is I'm going to get a 45-day reset. If she has everything before that date, all she has to do is come back to court and say, I have everything. and we'll bring you back in court before the 45 days. Do you understand? All right, Ms. Ferguson, I need a 45-day reset.
It'll be April 3rd. That's 44 days.
All right, we'll bring you back on April 3rd, and that's to make sure that she has all of the discovery.
One last thing, Your Honor.
Yes.
My client and I have discussed what is missing, but we are still waiting to see for an offer from the state this morning. So if I can just have a few more minutes with him.
I'm sure.
Before they take him back. Your Honor.
Yes.
Thank you, Judge.
You're welcome.
Morning, Your Honor.
Good morning. So, Mr. Foley, I haven't seen you since our last trial here together.
It has been a minute,
Yes. So any new vegetarian places?
really. I think there's just, they don't, they're not open.
No, I'm not, but I am.
You're
I enjoy
dabbling?
good food.
Okay,
So I love all things green.
okay.
Right. It took me a while to love Brussels sprouts, but then I just realized they were not being cooked.
All right, pause right here. This is where the case officially gets real. A new indictment just dropped, which means prosecutors believe they now have enough to formally move forward. And notice how fast discovery becomes the battlefield. That's where cases are won or lost before a jury ever hears a word.
Appropriately. And I discovered once you cook them appropriately,
They're
they're
okay.
no longer healthy. You know, when you throw in the maple syrup and the bacon, it's like,
Yeah,
but Sean, am I right?
that's fine.
Yeah. My mom would always, you know, you would have the day where you would have to have fish and you'd have the day where you would have to have cabbage. I'm from Louisiana, so you put the hot sauce on the cabbage, it's good to go. But when she would do the Brussels sprouts, I just can't eat the baby cabbages.
Can't do it.
Oh, I can't sit down.
Well, you haven't had them with bacon and maple syrup.
Yeah, I have. I still, it's like every good recipe or every recipe that people have for Brussels sprouts is just some way to try to cover up
map,
the flavor.
right,
Yeah,
true.
so
Well, you know, it's the same thing for me with kale.
I will agree with you there.
Me too.
Yes, but I will tell you, one of the best places I've had for Brussels sprouts, which they're not healthy once I've started counting calories, Cheesecake Factory. Their Brussels sprouts are
Oh, they're
great.
good.
Oh, yeah.
Oh, they are.
Okay.
And you're just,
All right.
and also Zokas.
Oh, yeah.
On the Riverwalk, their
Right.
Brussels sprouts are great. All right, so today,
And now the unpleasant matter of
yes,
Excellent.
it's never unpleasant because I get a chance to see you all. All right, so today is plea deadline date.
yes, Your Honor.
So are you all requesting a jury trial?
Well, Judge, at this point, the court might recall, I just brought you an order for additional funds for the mitigation experts. So
Yes.
they are trying to finish that up so that Mr. Foley and I can present a mitigation packet to the committee so that we can make a plea bargain offer to Jason for him to take upstairs. So what we would actually like to do is extend that plea bargain deadline if we possibly could so that we could make that happen.
And Judge, we do have authority from our client, explore, please. So we do think this thing.
So how much time would you all be asking for?
I would say 6 weeks if possible.
All right, so Miss Ferguson, I'm going to need 2 dates from you. First, I need a date for 6 weeks from now.
April 1st.
All right, is that April's Fool's Day or is that the real date you're giving me?
It is April Fool's.
All right, and then the next date I need is a jury trial date. How long would you all expect a jury trial to last?
I'm going to say, I don't know, Jason, what do you think? In 2 weeks?
Yeah, Judge, I mean, probably a little less than Tamor McIntyre, so probably 2.5. I mean, 1.5. rather.
All right, so I've been in trial with Mr. Foley before.
So
Which is, there is a
So
folly
there was
factor.
Not that many videos, but I mean, if
There is a
So-
folly factor. I will agree with that.
Which I'm fine with, but I just want us to be prepared. All right. Because if there is, I just need to be prepared because I was in trial with Mr. Foley and I actually enjoyed, because both attorneys were very well prepared, but it was a trial where the next thing I know, I said, how long have we been in trial? Has this been 2 weeks? And Deputy Lawrence, like, Judge, we've been in trial for a month.
Yeah, I know.
Yeah. So
Thought you were gonna say 3 days.
now it was longer than a month. Like, oh my gosh. So
And that was on an ag assault.
no, that was a murder case.
Remember, the murder was the other kid.
Mhm.
The capital murder was the other kid. This was the ag assault. The from the second kid. Remember, because they brought the victim in and put him on the.
No,
Oh no, I'm
no,
sorry. No,
no.
you're right. It's Brianna.
I was like, yeah, you're challenging he's challenging my memory.
Yeah, right.
Not happening.
Like Ingrid Bergman, is this gaslight? Are you trying to gaslight me?
Tried those two back to back. Remember?
Yeah. All right. So, what date?
I think they're pondering here.
All right. And there's going to be a gap of time because we have capital murders and murders that are already set.
that's a holiday.
This moment right here might sound lighthearted, but legally its huge defense is asking for CPS records and additional audio that's code for there may be more to this story than what we've been shown. Question for you: if key records are missing, should a case even move forward?
Well, the beginning of November is an official holiday.
Oh, I know that does.
That's what a Scorpio say. Oh, but like,
November 11th is a holiday, Judge, for Veterans Day.
yes.
I mean,
Unless y'all pick on a Monday.
And I will tell you, I always tell jurors, don't wave the flag and then not want to serve on jury duty, because only two things are asked for you: pay your taxes and serve on jury once in a blue moon. So what are you all saying? Do jury selection on when?
The 10th, Monday, the 10th, and then
All right.
start the 12th because the 11th is a holiday.
All right. Is that going to interfere with people's Thanksgiving plans?
The Thanksgiving should
it
be,
possibly could.
Oh, yeah, good point. But if-
well, that is a good
Yeah,
point.
No, we're gonna move with a purpose. So let's do that jury selection then on, if the holiday is on November 11th, do people usually take that Monday off
They
to travel?
do. They do. I try to.
All right, then this is what we can do. We can either do jury selection on the 10th, or we can do jury selection on Wednesday, the 12th. And if we do it on Wednesday, the 12th, we'll start in the morning and everybody has all day for jury selection. And state, I won't expect testimony on that day. It would just be for jury selection.
That'd be fine with the state judge.
I think that's probably best, Judge.
All right, so November 12th.
November 12th, Wednesday.
And then if I end up with my mom for Thanksgiving, Angelini will finish you up.
What a treat and a treasure.
Don't threaten me with a good time.
What a treat and a treasure.
Or either I have my mom come down. Mom, can you come down? All right, so November 12th.
Okay.
And then if my mom comes down, she'll say, no more objections. That's my baby. All
Get
right.
this show on the road.
Yes. So this is what is happening so you can understand. So everyone is going to be back here on November 1st. Your counsel will
April 1st.
April 1st. Why did I say November 1st? April 1st. Your counsel will provide whatever mitigation they want the state to review to see if there's an agreement that can be reached. State, if you need time to look that over, there may be another date before your November 12th date if they need more time. But November 12th, because of everything that's going on with discovery and so many moving parts, that's going to be your jury trial date and your plea deadline date. Do you understand? Do you have any questions about anything? All right. Anything else from either side?
No, Judge.
All right. No more face tattoos. Okay. All right.
Yes. Thank you, Judge.
You're welcome.
Morning, Judge.
Good morning. How's everything going?
Busy for Tuesday,
Yeah, because when
Monday, ruined.
yes, it's Monday and a Tuesday.
Yes.
I kept saying Monday, and then people were like, no, tomorrow's Wednesday. I'm like,
Yes.
okay. All right. So on this case, we're here for a violation report. Is that correct?
Yes, Judge. He had a PR bond on a PG2 1 to 4 awaiting indictment,
Mhm.
and then he also had a less than 1 gram subsequent to that. He's on a PR bond for the first case, and then the YSL bond company for the second case, to my knowledge.
All right. So state, in regards to these cases that the court has for the violation report, it's for drug cases.
The office
And the
date-
office date is 2023. Have there been any labs?
Judge, I know on the newer case that, from 2024.
And in the meantime, could I tell you a little bit more?
Sure.
Mr. Chavarria is working. He's 19 years old, correct? 18 years old. He's working at a car wash place. He gets $19 an hour. He paid for his bond. He got a PR bond for one, but he's been paying for his bonds. He's been checking in.
Okay.
He's made appearances in County Court 12. He's never missed a setting.
Okay.
And he's scheduled to be in County Court 12 next.
So why was he rearrested? Because the violation report I have, the only reason why you're here is because they said you were rearrested on the County Court 12 matter and then a drug case matter. And then,
Yeah, you guys-
sure.
And so we just received a wrap on the 2023 case, like 5 days ago.
Mhm.
So will get someone on indictment or attempt to do it myself.
All right. Let's go just one moment.
I can give it back to you.
Because it appears that your client is doing well, counsel.
Yes, Judge.
The same conditions. And then what we can do is we can recall this to see about the other cases, and maybe that may take care of everything. You understand?
I think that the reason for the violation report is because he was rearrested for DWI as UCW and being arrested on February
Yes.
6th.
Yes.
So I just given
Okay, we can go on the record. All right. We're on the record in Night Mag.
Did you catch that the judge just acknowledged something critical, potentially exculpatory evidence that means information that could actually help the defense, and when sealed or unindicted cases come into play, things get messy fast. This is where transparency versus procedure collide.
Number 743129, State versus Emmanuel Chavarria. Can I have parties announced for the record for the state?
state
Defense.
Joseph Stateson.
And you, Mr. Chavarria?
Yes, ma'am.
All right, the court is in receipt of a first violation report and a second violation report. Based upon the violation report, it was filed due to your being rearrested on previous cases. And I'm assuming, since it says rearrested, he had made bond for those cases previously. Is that correct?
To my knowledge, he had made bond on all those misdemeanor cases as well.
All right.
He was already magistrated.
So, State, what are you requesting in regards to the violation report? All right, defense.
A judge, my client's working. He's 18 years old. He can't afford to lose his job. He posted bond on his misdemeanors, and he has his mother here in the gallery who's relying on him to make house payments, utility payments. He does have one child who lives with him. He's not married. He has a girlfriend. One child is expensive and it's a lot. And he has expenses for child support, not child support. He doesn't owe child support. He's appeared in County Court 12 every time. He's never missed a setting. He checks in with pretrial. He's willing to report more frequently. He's asking if he could have his bond stay the same, and if not, have if we could have like a summons and have a pretrial setting to see about disposition within 30 days.
All right. And Mr. Chavarria, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand, state your name for the record.
Emmanuel Anthony Chavarria.
All right, on your bond for the driving while intoxicated in misdemeanor court, are you required to do any type of drug testing of anything of that nature?
Drug testing.
Your analysis. Does anybody test you to see if you're using alcohol?
My job, they do daily, like monthly drug tests and stuff.
All right.
If they see that you're acting weird, that they'll drug test.
All right, so you're receiving drug testing through your work?
But sometimes just not.
All right, so my question is, you have cases in misdemeanor court. Do you understand that? One of them is driving while intoxicated, and I don't want to get into any of the facts of that case or what people think the facts are, but are they giving you any type of drug testing for that case? Do you have to urinate and have people check your urine?
No, ma'am, I haven't got drug tested for that case.
All right.
They took blood though. They took blood out of me.
Okay, that's related to something else, to see if you had alcohol in your system while you were driving. Have you ever used any marijuana in the past or anything of that nature?
Like when they had to pull me over, yes, ma'am.
Okay.
But not that day. I wasn't smoking or drinking that day.
Okay.
I just had it in my possession.
Okay. All right. So this is what the court is going to do. The court is not going to increase his bond. And I know judges are not supposed to tell why, but let me just tell everybody why I'm not increasing his bond. The drug cases have been pending since December 2023. The state only recently received the labs. And if either party wanted to, these cases could have been dismissed for further investigation under 32.01 of the Texas Code of Criminal Procedure. So I'm not going to increase your bond, and state it. Of course, it's up to you whether you're indicted or not, but he's 18. He doesn't have any more money to afford any more bonds. What I can do is I can reset the night mag cases before you indict, if that's the route you choose, and defense, you and your client can appear. And if you all are able to reach agreement, then that's completely up to you all. If you're not able to reach an agreement, then we'll head towards jury trial.
I would like to have a chance to negotiate for resolution.
All right. So state, we can go off the record. State, are you in? I know he's going to ask for how much time?
Within 30 days.
All right. So he's going to ask for 30 days. Are you all going to indict that before 30 days or?
No, I'll confirm.
All right. So what we'll do is we'll recall this. Ms. Ferguson, if I could have a 30-day reset on Chavarria for the night mag cases, and they're going to ask for drug testing. I'm going to ask that the fees be waived based upon his finances.
March 20th.
All right, so we're going to come back on each of these cases on March 20th. And you work, is that enough time with your employer?
Yes, ma'am. I'll tell them if I can get that day off.
All right, if for some reason you're not allowed to have that day off, counsel, he can appear by Zoom.
Yes, Judge. Thank you.
Is there anything else?
No, Your Honor.
All right, thank you. Once you sign the reset form, you're excused.
Let's see that. Yeah.
All right, David Rocha.
Yes, ma'am.
All right.
This is one of those rare courtroom moments where the judge lays it all out. A 45-day reset isn't a delay tactic, it's a safeguard. The court is basically saying no surprises, no shortcuts, full fairness. Do you think courts should be this patient, or does it slow justice down?
Need to show your video?
Can you see me?
Yes, I can.
Okay.
So this is set for hearing. He's requesting early termination.
Yes, Judge. A status report for early discharge was sent into the court last week or so, and at the time it was sent to the court, it was denied. The state opposed the discharge, and Mr. Rocha would like a hearing to discuss it.
All right. So, Mr. Rocha,
Yes, ma'am. Yes, ma'am.
attorney, and I don't know if he's still your attorney or not, Mr. Allen.
Right.
He's not going to be available till another 30 days. So if you want to wait for him, if Mr. Allen is still your attorney, we can wait for Mr. Allen.
I don't mind.
It may be in your best interest to have him represent you as far,
Okay.
if he's still your attorney, as far as the early termination is concerned.
Okay, we could do that.
All right. So, Ms. Ferguson, what date? Because they sent out an email with Mr. Allen requesting that his cases be set off for 30 days. What date do you want to bring this back?
I think it's March 31st.
All right. So what we'll do is we'll set it for March 31st.
Okay.
Okay.
Sounds good.
All right. Thank you.
Thank you.
You're welcome. Bashan, I had no idea that Matthew Allen was his attorney until I looked it up.
Oh, right, Judge. After speaking with the state, he gave me the reasoning on why he was opposing at the time, and he was just going to tell you why. But Mr. Rocha has finished everything, and he's doing well. So hopefully on the 31st, we can come to some resolution. Thank you, Judge.
You're welcome. Thank you, Mr. Rocha.
You're welcome. Bye-bye.
Bye-bye. Hello.
I can be a text message.
Who's your attorney?
I don't remember his name, honestly.
It's Robert Mauer.
All right. Your attorney is out of county in Travis County, and he's asking that your case be recalled for tomorrow. So we'll bring you back tomorrow to take care of your matter.
Yes, ma'am.
All right. Do you have any questions about anything?
No, not necessarily.
You sure?
Yes, ma'am.
Okay. All right. We'll call you back tomorrow. Sorry for waking you up.
That's all right.
All right. Thank you.
That's a Wednesday, so it's okay Wednesday.
Oh, it is Wednesday. I forgot. We're on Tuesday, right? So then what I'll do is I'll call you back on Thursday. I'm sorry. I forgot that it still feels like a Monday. It feels like a Monday. Definitely hit me here. So Monday and Tuesday, whenever we're off on Monday, Tuesday becomes a Monday and a Tuesday.
Oh, okay.
Because we're playing catch up. All right. So we'll bring you back on Thursday. Okay.
Yes, ma'am.
All right. Thank you.
And get it is also out here, Judge.
All right. Mr. Guerrero, can I see you? Hello.
Good morning.
Good morning. Your attorney is actually out of county.
Okay.
So what I'm doing is I'm going to call you back for your plea deadline date on March 17th. And on that date, you need to let the court know whether or not you've reached an agreement with the state. Do you understand?
Yes, ma'am.
Do you have any questions?
No.
All right. Thank you.
All right.
Vashawn Gibson is being recalled for the 20th. State, did you tender an offer?
Your Honor, at this time, we have been conferring. We had tendered an offer, defense has a counter offer. Before the state can actually consider that, we're just waiting on CPS records.
All right. So where are the CPS records? Because this case has been on the docket since November.
We subpoenaed them last week, Your Honor.
All right. So are they in the cut? Is there an open CPS case?
There is.
I don't know if there's a legal case, Your Honor. I think there's just on the regular CPS side.
Okay.
I think it's in family-based.
All right.
rather
So
than legal.
has anybody reached out to the CPS caseworker?
I can ask our advocate to do so.
All right. I'm recalling this back for February 20th. That's Thursday.
We can do it next. Well, any chance for the 27th? just,
All right.
just a week later.
All right, I'll put it on.
And Judge, while we're here, my client's been in custody since September. We respectfully request a oral motion for bond reduction with.
Well, the way the law is now, you'll have to file a motion and I'll hear it and we'll put it on the docket as soon as you file it. If the state is waiving notice.
I think there's one on file, but we'll get it set for the 20th.
If it's on file.
I think my client, actually, Judge.
All right, if you want to adopt your client's motion, if the state is waiving notice, then I will hear it.
Your Honor, I would need to look at the motion and maybe just confirm, see if there's an agreement that can be reached.
Okay, Judge.
All right.
I'll just file one. Let's just do it for the 27th.
Well, they're saying that they'll look at the motion and see if you all can reach an agreement. So do you want to talk to them now? Or do you want to file your own and come back on the 27th?
We'll chat right now.
All right, thank you.
Let's chat.
Sure.
Have a seat, sir.
No. All right, so Mr. Salazar, I'm in receipt of the motion that you filed. What I can tell you is, unless there's an exception, PR bonds based upon the legislature and the rule.
Now watch the shift in tone. We've gone from discovery battles to plea deadline strategy. This is chess, not checkers. Defense is buying time to build mitigation, because sometimes the strongest move isn't trial, it's leverage.
They pass and the laws they pass. PR bonds are not given for violent offenses. And because this is an aggravated assault with a deadly weapon, you're not going to be able to receive a PR bond from the court unless there's some exception that your attorney wishes to present to the court. So with that being said, the court is calling, let me find you, 2024 CR 009128, State versus Cody Salazar. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Defense.
Robert Gear for defendant Cody Salazar, Judge. We're ready.
And are you Mr. Salazar?
Yes, ma'am.
All right. And defense, are you adopting your client's motion to set, it's a motion to grant a personal bond. Are you adopting that motion?
Yes, Judge, we'll adopt that motion, and we'd like to argue, if not for a PR bond, for a reduction in bond as well.
All right. So state, the motion that the defense counsel is adopting is a motion requesting a personal bond. That's it. It's not a motion for a bond reduction. So any objection to defense counsel amending his client's motion and requesting a bond reduction?
No, Your Honor, and I will state for the record that there were a couple motions filed. I do believe one of the ones the defendant filed was a motion for reduction of bond.
All right. Do you have that motion? If you all could print that out. All right. So defense, it's your motion. You may proceed.
Yes, Judge, may it please the court. My client was arrested on or about September of last year. We've been coming to court since November. State's attorney is correct that we have been conferring at every court setting. However, we're still here in the need of more discovery in the way of CPS records. And since my client obviously has been to court every day, but not only him, his family's been here. His mother and sisters have been very supportive of him. Bond and bail should be set in an amount that is sufficient to require or have the defendant submit to court and make all his court appearances. There is also a condition that I saw on the bond by the magistrate of a GPS with house arrest, and considering the nature of these charges and that bond condition, I believe it'd be in the best interest of society and my client and myself as representing him and being able to discuss this matter with him, that the court reduced his bond to a reasonable amount so that he can bond out, number one, because he has been sitting there without much movement on the case because we're waiting on discovery and waiting for CPS records. Number two, it'd be easier for myself and him to communicate. Were we out? Should we have to prepare for trial or any hearings or other further settings in this matter? Considering the conditions on his bond, we believe that those are adequate enough to secure himself with society and in the eyes of this court. And therefore, Judge, we'd respectfully request that the court reduce this bond to a $20,000 to $40,000 bond range, so that my client, with all the conditions that are already in effect, will move my client's constitutional rights. Thank you, Judge.
All right, so what bond are you saying he can make? And do you have any testimony to determine the bond amount that he can make?
I call Cody Salazar, Judge.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Cody Salazar.
All right, defense, you may proceed.
Thank you, Judge. Cody, at the time of this arrest, where were you residing?
I was at my mother's.
And you've resided there for quite some time?
Yes, sir.
And you have been incarcerated how long?
5 months now.
Okay, so you currently don't have any occupation and you're not working.
Yes, sir.
And if you were to be released, you'd have to look for a job because you don't have one waiting for you, correct?
Yes, sir.
But your mother does work, correct?
Mhm.
And she's had a steady job for quite some time.
Yes.
And she cannot afford a huge bond as the current bond amount. Is that 100,000? That's a little bit out of the range.
Yes, sir.
Do you believe she'd be able to afford a $20,000 or $30,000 bond?
Right now, I have to ask her. I mean, I don't know. I don't really know.
Would it be easier for her to afford in the bond in that amount than what the bond is currently set at?
Oh, yeah.
And property, other than her house, does she have any other property that she may be able to sell or get money for a bond?
I don't think so.
Okay, do you have any property that you'd be able to sell and get money for? So you're asking this court to reduce your bond to an amount that you believe that your mother would be able to afford to get you.
All right, so we can go off the record. So what I need is, what have they done to secure a bond? How much money do they have? Do they have any money in the bank? So,
Judge, if I may,
yes.
May I call another witness?
Well, just one second. Any questions, State?
No, not for this witness, Your Honor.
All right, thank you. Yes, you may call another witness.
This ruling right here is a big deal. The judge refuses to increase bond, calling out delayed lab results and reminding everyone justice delayed by the system shouldn't punish the defendant. Drop a comment should bond decisions factor in how long the state takes to do its job.